Okay, good afternoon, everyone. This is Ann Badmus with Badmus Associates. I'd like to welcome you today to our Immigration Primer for Physician Recruiters webinar. Before getting started, I always like to test to be sure that everyone can hear me. So if you can hear me, someone just type in the chat, yes. Great, I've got some yeses here. Thank you so much. So again, welcome, and let's just go ahead and get started. I want to let everyone know that the good thing about this webinar is that you can ask questions at any time. And to do that, you want to use your Q&A bubble section at the right of your screen, at the top right of your screen, or if you're on your phone, it could be somewhere there as well. But basically look for that Q&A section and please type your questions there as we go along through the webinar. For confidentiality reasons, we always ask that questions be asked in general and not to identify any personal details of any, whether it's yourself or your candidate or client. All right. So just a little bit about Badmus Associates. For those of you who have not worked with us before, we have been working with immigration clients since 1993, have been honored with best law firms, or immigration law firms in the U.S., and as well as some best lawyers list in the U.S. and best lawyers in Dallas as well. But most importantly, we are a National Association of Physician Recruiters vendor member and have been so for, I think, almost 10 years, if not more. So again, welcome all of you who are attending this webinar, who are also NAPR members or NALTO members. So a little bit before we go on, we always, as attorneys, have to let you know that the information in the presentation really is information, not necessarily legal advice. And as you probably know in your work, that you will probably be encountering a lot of different unusual circumstances. And we're hopeful that this will at least this webinar will just give you a basic knowledge so that you can at least identify some issues and, if necessary, contact an immigration attorney, another qualified professional as well. Now, our webinar agenda is we're going to talk generally about avoiding discrimination claims, talk about J1 physicians, also H1B physicians, or how to place those, or what considerations to consider in placing those, and just a few special cases to consider. And then I'll respond to questions at the end of the presentation. Just as a general overview, this is sort of our roadmap of how a foreign-born physician can eventually permanently work in the United States, as well as temporarily work in the United States. So as you can see, of course, they go to medical school, either through a U.S. medical school where they would typically have a student visa to do that, or an international medical school in their own country or some other country. And then, of course, they would have to match into a residency program or a fellowship program in order to get the necessary training to qualify for licensing, just like any other physician who is born and educated in the United States. But for the foreign-born physician, after residency or even to be included in residency, they usually have to have a visa in order to come to the U.S. and undertake that residency or fellowship program. And typical ways they do that is either as an exchange visitor, or the J1 visa, which is the exchange visitor visa, or the H1B visa, which is considered the professional workers visa. There are different considerations for each, but uniquely for the J1 visa, there is a requirement that the physician, after training, either return back for 2 years or get a waiver of that 2-year home residency requirement, which we'll discuss in more detail later. But after that, of course, we're now looking at, after training, how do they work in the US? So there's various options. As I have listed here, we'll basically really discuss the H-1B option. The other options are pretty rare and probably for another webinar, but I did want to make sure that that is mentioned. Those are mentioned, and you see that there are potentially other options besides the H-1B visa. But of course, H-1B visa and those other visa options are temporary. So most physicians who want to be here long-term want to have permanent residence or be qualified for permanent residence relatively shortly after they've obtained their first permanent job. And so these are the options there. And after permanent residency, once they have, for a certain period of time, held permanent residency, they are eligible for citizenship and no longer have to be concerned with immigration matters at that point. So, as I mentioned, our first bullet point that we want to cover is avoiding discrimination claims in hiring. So as recruiters, of course, you are working with your clients and the candidates and need to be mindful of anti-discrimination laws, generally related to, of course, there's always the EEOC, the Equal Opportunity Employment Commission that covers all people in terms of anti-discrimination. But what we're focusing here mainly is what we call immigration discrimination. So there are specific immigration laws that prohibit discrimination in hiring, which includes unequal treatment of a candidate or a potential employee or a current employee because of citizenship or immigration status, because of nationality, or in particular, when qualifying or obtaining verification information about an employee's eligibility to work, a no-no or anti-discrimination requirement is that there cannot be, the employer cannot ask for specific documents, or you can't ask that you only want to have green card workers or qualified or for your position. And you also cannot have a citizen-only hiring policy unless you are working with a government organization that requires that. So it's important in your job postings and your recruitment discussions to avoid any claim or advise your clients that they cannot require only U.S. citizens or green card holders, or even saying only H-1B workers, or any of these kinds of things that will basically eliminate or require someone not to be a, or eliminate eligibility for those who actually are legally allowed to be here, but are to work, but are not eligible for, are not U.S. citizens or green card holders. So best practice when you are encountering any candidates, but in particular, if you understand that the candidate might be a foreign national, you want to be sure that you are asking these types of questions, which are just general questions, not implying any kind of disparate treatment because of their immigration status. So are you currently authorized to work? Yes. If they say yes, of course, there's no further questions into, well, what is their immigration status or what is their citizenship, that kind of thing. The inquiry should stop there. But you can also ask if they are now or in the future require sponsorship for employment visa status. That will kind of give you an idea of whether or not there is a visa. But oftentimes, if you are encountering candidates, especially physician candidates, they will tell you from the beginning what their status is, and that's perfectly fine. They can certainly volunteer that type of information, which will give you an understanding of what might be some require, or will give you a flag as to what that immigration requirements might be necessary. So next we'll talk about placing J1 physicians. So as I mentioned, you will oftentimes, especially if you are recruiting from residency or fellowship programs, new physicians, you will encounter physicians who are in J1 status, which is a status solely used for their training. It is not a work status outside of training. So when finding a J1 or encountering a J1 physician, you have to be aware of some of the requirements related to that visa. that they have. And in particular, as I mentioned earlier, all J1 physicians who have come to the U.S. in order to do residency or fellowship training are subject to the 2-year home residency rule, unless they obtain a waiver of that residency requirement. So what that residency rule says that the physician, after their training, must return to their home country, the country where they were permanent resident before they entered the U.S. for training. They must return to that home country for 2 years or obtain a waiver of this 2-year requirement before they can be employed in H-1B status or get a green card. So what that means is that most of the physicians that in that situation where they are coming out of training in J1 will need a waiver of the 2-year home residency requirement if they want to immediately work. So if you encounter that physician, then these are typically the 3 options for a physician to get that waiver. The most common one is the interested government agency, where there is either a state or federal agency that is willing to sponsor that individual physician to work in a state that is under their jurisdiction. So we'll talk more in detail about that, and that's really going to be a focus of our presentation today. The other 2 ways are personal applications by a physician showing that either they have exceptional U.S. citizen spouse and children who will suffer exceptional spouse or children, I'm sorry, having U.S. citizen spouse or children who will encounter exceptional hardship if they are separated for 2 years because the physician has to return back to their home country. The other waiver is the persecution waiver, which is very similar to what's considered an asylum claim, where the physician believes that if they return to their home country, they would undergo persecution because of political or religious beliefs, certain kinds of protected beliefs that we have in the U.S. They would be persecuted if by the government in their home country or by persons who the government will refuse to control in terms of those types of issues or danger to their lives or to their livelihood. So we won't go into those 2 categories because they are pretty unique. The most important ones that you will encounter will be the typical interested government agencies, or IGAs, as they're called. So these currently are the most typical agencies, or actually probably the only agencies that you will run across in terms of the waiver process. So we'll talk in depth about these, but in summary, they are Conrad 30 state programs. So these are administered by each state. Each state has its own policies and procedures for this program. Then we have the Department of Veteran Affairs, which actually, again, is a very specific waiver for only the Department of Veteran Affairs. And typically, you probably will not run across that unless you're recruiting for the Department of Veteran Affairs, which is unusual. So really, the Veteran Affairs will take care of that kind of waiver process directly. But the other types of waivers that you could encounter or could be options for your physician candidates would be the U.S. Department of Health and Human Services, the Appalachian Regional Commission, the Delta Regional Authority, and the newest one is the Southeast Crescent Regional Commission. So let's go in depth into each of these programs. So as I mentioned, the Conrad 30 state program is administered by each state. Each state is allotted 30 slots, 30 physicians that they can sponsor each fiscal year, which starts in October and ends in September. Even though the fiscal year starts in October, some states will accept applications in advance of the fiscal year, a few months perhaps, like for example in August or September, but they cannot issue the waiver approval until after October. So there are varying deadlines and opening dates. So you have to check each state to determine when they will start to accept applications. And each evaluation process can be different, although there are some standard requirements that the federal government has imposed on the states. The states do have some discretion to determine whether or not they will approve any physician and employer who applies for the waiver. Unfortunately, if a state does not use up all its slots, there's no rollover, so it's sort of a use it or lose it situation. And there are a few states that do encounter that. All of the states usually require that there have been some. All of the states require that there's some proof of recruitment, that there has been recruiting done to look for physicians who may be U.S. residents, already U.S. residents, or already U.S. citizens. So it's important for the recruiter, of course, to have that documentation on hand so that the employer can easily meet that requirement. The other requirement that is required for all states is the location be either in a health professional shortage area, or what we call HPSA, or a medically underserved area or population with MUA. You can find by address whether or not your proposed facility is in a underserved area by clicking on this link here, or just Googling HPSA, shortage area, a designation. You can find the link where you can locate whether or not your facility is underserved. However, there is sort of a small exception for work locations that are not underserved, and those are called the 10 flex spots. So, flex spots or slots, either one, but a flex slot basically allows for a waiver, allows for a state to use 10 out of those 30 slots for facilities that are not located in an underserved area. So, for example, if a hospital is not physically located in an underserved area, but the physician will work in that hospital and serve patients who will be coming from surrounding underserved areas, whether it's in the same county or a different county, then they can potentially qualify for a flex slot. It does require a little more information from the employer, in particular, proving that they do have patients, a significant number that come from underserved areas, and providing that data before the state can approve that kind of waiver. The other requirement is a 3-year minimum contract, and we'll see that pretty much in all of the waiver programs. But some states actually require 4 or more. It's very rare, but some do require more. But at minimum, a 3-year contract is required, and most states will not allow a non-compete clause or a non-competition clause. And all of the contracts must state that they agree, there's an agreement at least to start employment within 90 days of receiving a J1 waiver, although 99% of the time that agreement will fall through because of the waiver process itself, but that has not necessarily been a hindrance to actually getting a waiver or actually allowing the physician to start work. Also to consider is primary care or specialty is usually accepted by almost all states. However, most states give priority to primary care. And hospitalists are sometimes considered specialists in some states. So if you are working with hospitalists or other specialists, it's important to look at the state and determine whether or not how they prioritize these types of specialties. The next agency is the Department of Health and Human Services that we run across frequently. And that agency has actually been almost a go-to agency nowadays because it does cover primary care. Well, first of all, it covers the entire United States. And it is for primary care physicians only, but it includes hospitalists as well. So if you have hospitalists or other primary care physicians who are going to be working in an underserved area where the HPSA score has at least 7 and above, and the majority of them do, then this could probably be the go-to waiver as opposed to a state waiver process, because there is no limit on the number of waivers per year. So you can apply year-round. So if you have a physician who has missed a Conrad 30 deadline, or is very soon needing to get a waiver as soon as possible because they're very close to the end of their training, then this might be the best option for them. But it is important to note that if you have a physician who has been, for example, finished their internal medicine or family practice or some other primary care residency, and it's been more than a year, or it would be more than a year that they finish their residency before they can start work, then they would not qualify. So it's important to look at when they are completing their residency and how soon you can get them into the process. Another agency is the Appalachian Regional Commission. This covers mainly northeast to southeast, northeast to southeast of the U.S. You can find the different areas that they cover by going to arc.gov, starting anywhere from New York all the way to Georgia, where the Appalachian mountains, I guess, go. So again, they require, like all the others, 3-year contract and proof of recruitment. They do require only HPSA areas, so medically underserved areas typically don't qualify, but they do also accept primary care and specialists. And another good thing about it is that they do not have a limit on the number of waivers, so that is available all year round. Another waiver is the Delta Regional Authority. Again, it is a regional waiver as well. It covers about 8 states, starting from Illinois all the way down through Alabama and Louisiana. So if you have a potential match there, then that could be another option rather than a state program. It's 3-year contract required with no non-compete clause. There is, it can be in a HPSA or MUA area. It can be, the candidates can be primary care or specialty, and there's no limit on the number of waivers per year. However, it's important to note that the recruitment, there is very specific recruitment requirements, which requires that there be at least 45 days of recruitment activity before applying for the waiver. And some of that recruitment activity requires national and local advertisement, as well as state medical school notices. So that's important to know in doing your recruitment if you're working in this Delta Regional Authority, to know that that's the kind of recruitment that needs to be shown. The last waiver organization or agency is the Southeast Crescent Regional Commission, which recently started offering waivers. I think it was in September 2020, or no, I'm sorry, 2022, that this program, or 2021, one of those date years, and not too long ago, that they started to offer this. And so again, it does cover certain states, starting from Virginia all the way through Florida, and about 400 some counties in those cumulative counties throughout those states. So it is not, if your candidate will work in one of the counties that is covered by the SCRC, then this could be an option. They do accept specialists as well as primary care. There's no limit on the number of waivers. And like the DRA, there's a 3-year contract and no non-compete clause. And the recruitment needs to be conducted 45 days before application. And also importantly, it does require very specific recruitment, such as national and state ads, as well as medical school notifications. So some things that you should know, or your candidate and your employer should know with respect to J1 obligations, J1 waiver obligations: the physician must work in H1B status for 3 years. So he or she cannot use a different type of visa, like an O1 or E2 or some other visas that they think they might qualify for, or E3, for example. They cannot use those. They must use an H1B visa during that time frame. So that is absolutely required. They must be an employee, not an independent contractor. So they must receive a W-2. The employer and the physician, most agencies require that throughout the 3 years, they update the state or federal health agency as to patients being seen and different other questions they might ask to get statistics on the physician's practice. The physician cannot change employers within that 3-year time frame unless they prove what's called extenuating circumstances, meaning that they are having issues that are beyond their control. So, for example, termination by the employer or employer misconduct in their view, those kinds of things they have to prove in order to be able to change to a new employer. So oftentimes you might receive candidates who are looking to change in the middle of or within their 3-year waiver obligation. And so it's important to know what are their reasons for changing, because unlike other H-1B candidates, these particular J-1 waiver physicians must provide a good reason for changing in the middle of their waiver obligation. After their waiver obligation is done, they do not have to provide such a reason. They can certainly go into new employment, whether it's in an underserved area or not. But if they are trying to change and complete their waiver with a different employer, then they're going to have to provide those good reasons why they should do that. And that new employment must also be in an underserved area, whether it's in the same state or a different state. And another thing importantly to know for physicians is that they cannot be, for J-1 physicians, they cannot become a permanent resident until they've completed their waiver service. So after they've done their 3 years, if they're otherwise eligible, they can get their green card, but not before they've completed their 3 years. So timeline to consider when you are working with J-1 waiver physicians. Your employer and the physician have to apply to the interested government agency. And usually it takes anywhere from 1 to 3 months for that IGA to make their decision. If they approve it, then it goes next to another agency called the Department of State. The DOS issues a recommendation within about 1 to 2 months. And then they send their recommendation to the USCIS, which is Department of Homeland Security, which issues the final waiver approval. Sometime during that process, an H-1B petition is filed by the employer in order to get the actual H-1B visa so that the employee or the physician can work. So overall, that time frame can be anywhere from 4 to 12 months. But on average, I would say about to factor in about 6 months. But if you get a candidate that needs to start or an employer that needs an earlier start, it is possible. But it's certainly not something that's in a few weeks. You would expect at least months before that physician can actually be eligible to work. So this will be the strategic plan for placing physicians, but physicians themselves, the physicians should be starting their job search after their 2nd year of residency or before their fellowship is completed, at least 1 year before their fellowship will be completed, so that they can apply for these waivers and have the waiver process in place so that when they do complete their fellowship or residency, they can start July 1st or August 1st, whichever date is agreed upon. So next, we'll talk about placing H-1B physicians. And before we do that, I do want to remind everyone that you can ask questions during this process. So if anything comes to mind, go ahead and put your questions in the Q&A bubble that you have on your screen. So if you put that in, or if you want to put it in the chat, we have a good small number of persons, so I can certainly check as well in the chat. So just feel free to type your questions, and so we can have them available or answer as early as possible. So talking about H-1B physicians. So H-1B physicians come in various forms. So you can have an H-1B physician who is completing their residency or fellowship with H-1B. So that means they did not do their training in J-1 status. Instead, they used an H-1B visa where the program was willing to sponsor their H-1B in order to do the training. So you have those who are coming out of residency and fellowship that are looking for jobs. And now you have some considerations as to how you would place them and what type of immigration rules would apply to them and the employer. You also have J-1 physicians who actually did return home after their waiver. I mean, not after the waiver, after their training, So they did not apply for a waiver. Instead, they decided to go back to their home country for 2 years, but now they want to come back to the US. And so they are looking at options to come. So many of them will, the only option that will be available would be to get an H-1B visa to return back and work with the potential employer in the US. And then you also have a category of J-1 physicians who we consider to be H-1B physicians because they are going to look for jobs, and the H-1B visa is the visa that's going to be necessary for them to work. So those J-1 physicians who, instead of getting a interested government agency waiver, they got one of the waivers I mentioned earlier, which was either a hardship or persecution waiver. With that kind of waiver, they also encounter a unique situation that we'll discuss in a minute. So these H-1B physicians, they may come in any of these categories. And so when you find a physician, or a physician finds you that has that kind of situation, then what you have to be mindful of is what we call the H-1B cap. And the reason why is that these physicians, even though they're already here, and some of them might already have H-1B status, they may have to either compete against many other professionals for H-1B visas that are considered under the numerical limitations, or cap. So this cap applies to 65,000 or has a limit of 65,000 new H-1B visas that can be issued every year, and 20,000 additional for those who have U.S. master's degrees or higher. So we have a pool of about 85,000 new H-1B visas available each year. So if you're a H-1B physician, for example, the one that completed their residency with H-1B, more than likely they actually got their H-1B without going through this cap system, because they were sponsored by a university or a hospital that was cap exempt, which meant that they are able to get an H-1B visa regardless of this limited number. However, once the physician now completes their training, if they are wanting to work with a private employer that is not cap exempt, then you are looking at competing against competing in the H-1B cap. And it is a very, very competitive system. There is a lottery that's conducted every year in March, and typical lottery entries are about the number of lottery entries for this year, for example, was almost 400,000. So only 85,000 H-1B opportunities were issued out of that 400,000 that were sought. So as you can see, it's very, very competitive, and unlikely that a physician would be able to get an H-1B physician can get one of these cap slots. So in the search for permanent employment or other employment after training, it is going to be important for to look at certain types of employers that would not have to do not have to apply under this cap system. Instead, they are what's called cap exempt employers. So the categories that I've listed here are pretty much what the categories you will or the types of employers that you will have to look for. Those employers would be either universities or nonprofit petitioners that are affiliated with universities. So, for example, a nonprofit hospital or a practice that has a teaching component where they have interns that come from local universities, or a residency program that's co-hosted with local universities, that kind of thing. Or if they're going to go into a government research or a nonprofit affiliated government research organization. That's pretty rare for clinical physicians, but there could be some out there like that. And then the third category would be an actual private practice, for profit, However, the physician, for example, hospitalist, might be working at a hospital that is a nonprofit and has that residency program in affiliation with a local university. So if that physician will spend at least half of their time working there, and they will also be involved with some teaching of other residents or medical students at that facility, then they could also qualify for cap exempt employment. So sometimes it's not necessarily needle in a haystack, but it is a very defined search that you, or defined number of employers that you would have to screen to determine whether they could accept someone who is an H-1B physician that needs to avoid the H-1B cap. I put cap exempt beneficiaries here because I'm actually relating that back to the J1 physicians that we discussed earlier. The reason why they don't have to be concerned with the H-1B cap is because there's a unique exception that the government has carved out many years ago that exempts physicians who were J1 physicians, but they got an interested government, state, federal waiver. And so they do not want to have those physicians who are going to be working in underserved areas have to worry about competing for this very limited number of H-1B visas. So if you are encountering even though the J1 physicians have to get an H-1B visa to work under their J1 waiver requirement, they are not required. You do not need to be concerned whether or not the employer is cap exempt or anything like that. They can work for any private employer as long as they meet the qualifications of the waiver, and that waiver process has been approved for the employer. So some H-1B facts to know when you're talking about H-1B physicians. If an employee is already in H-1B status and they're changing employers, then they still need to have a new H-1B employer submit a petition. So we often hear the term transfer, and I guess technically it is a transfer in a way. However, the process is identical whether or not it's a transfer. So if you encounter a physician who, for example, they've completed their J1 waiver and now want to move to your client's site, that your client must file an H-1B petition before they can start working with your client. So you will encounter some physicians who already have H-1B status, and so it's not simply a matter of updating and including, providing the name of the new employer. Instead, that new employer must actually file an H-1B petition. Now, any employer is eligible for filing an H-1B petition, so there really is not any restrictions on that. Sometimes we do hear employers think that I'm not eligible. Well, that is a misconception, because any valid employer is eligible. Whether or not the physician or the location or some other factors might affect the eligibility, it really depends on the individual circumstances. So we have to look at the whole picture to determine whether or not the employer should go ahead with an H-1B petition for that particular match. Also important to know is if you are in a situation where you have someone with H-1B status and the employer files an H-1B, new employer files an H-1B petition, that candidate can actually start working without having a final approval. They can start working once the H-1B petition is filed. However, most employers and most candidates want to have an approval, and so that's perfectly fine. They can wait until the approval is issued before starting work. We also have, I think, a special situation, especially for those physicians and physicians you might encounter who want to work also, in addition to working with their current employer, they might want to moonlight. And so if they want to moonlight, usually they have to have, or the moonlighting employer must also submit what's called a concurrent H-1B petition. So that means that the physician has two H-1B employers. Some of them can have two full-time H-1B employers if they're willing to work in that manner, but essentially it is an option to have that. And what's important here that it can be a sort of workaround for the cap exempt issue that I just discussed. If you have a private employer who would not qualify for cap exemption and the H-1B physician needs a cap exempt employer, sometimes you can do this workaround if all things are in place. So for example, if the physician says, okay, well, I can work part-time at a facility that is cap exempt, like a local hospital that might be cap exempt. I can get an H-1B with them. And so I will be cap exempt in that sense. But so now that I've gotten cap exemption with that particular cap exempt employer part-time, I can now work with the private employer full-time if the private employer agrees to file a concurrent H-1B petition. So it is a little complicated, but it's very doable if you can get these two employments in place for that physician. This is also important to know. We often hear from locums recruiting agencies or locums agencies that they can't really work with these H-1B physicians because, of course, locums is temporary work, and you may not necessarily be able to agree to provide hours for a physician and also have to pay them even when they're not working, which is one of the requirements that happens with a H-1B, or one of the requirements of an H-1B visa. So we have worked with many physicians who want to moonlight, but they want to do it on their own. They want to have the flexibility to do locums or some other temporary employment. So in order to do that, what we recommend is that they set up their own company, whether it's, or their own practice, whether it's incorporated or an LLC, and do what we call an entrepreneurial H-1B. So if they arrange the company appropriately, they become an employee of their own company, and then their company contracts with the locums agency, hospital, or private practice to provide services as an independent contractor. And so the payments for their services go to the company, the physician's company, and then the physician's company is responsible for all H-1B requirements, including paying salary, issuing W-2s, all those things. So I worked with many physicians who like this arrangement because it does give them some flexibility. We also have worked with physicians who actually start their own practices in this way, using H-1B without having to have an independent, separate employer. In fact, they were using their own company and being self-employed in a sense. So talking about a strategic plan for placing H-1B physicians, again, same thing, very similar to the J-1. They want to start at the job search towards the end of the year. Towards the end or after the second year of their residency or 1 year before completion of their fellowship. They need to finalize their employment pretty soon before their fellowship, the year before their fellowship or residency completes. And if they are going to be competing, they do find an employer, they want to go ahead and try to apply for a cap subject employer, then they're going to need to get their contract in place and register for the H-1B lottery in March. If they do not want to do that, then yes, you have to focus on cap exempt employers to place them with facilities that would qualify for exemption as early as possible. So that concludes that part of the process. I just want to talk basically about the EAD, which some of you may encounter. You will find physicians that say, I have an EAD, so I don't really need sponsorship. So just to give you an idea of what that means or why they have an EAD and some considerations for that. So a physician can have an EAD for any number of reasons. They are issued for many different types of applicants. But the typical EAD that you will see with most physicians is those that are based on a pending green card application or a TPS, which is temporary protected status application. I really won't go into depth about that, but I will say that if they do have the EAD, then they are absolutely allowed to work for any employer. There are no restrictions on that in most cases. But the EAD is limited to a certain period, mainly either 1 year or 2 years. And so they must renew the EAD if they have not obtained permanent status before the EAD expires, and they have to renew it before it expires in order to have continued work authorization. If for some reason their underlying reason for having an EAD is no longer in existence, so for example, if their green card application is denied, then that EAD is no longer valid at that point. In some cases, particularly in those cases where you have a physician who is pending a green card and they want to use their EAD, you do need to determine how are they applying for their green card. Because if they were sponsored by their employer for the green card, then more than likely the new employer would at least need to complete a form called I-485J, which would basically say that we are offering this employment and their job is going to be very similar or the same type of job as the job that they are coming from and that they were sponsored for by the previous employer. So that could be an additional step. However, there's very little on the part of the new employer in terms of it's not really a sponsorship. It's not any obligation beyond their contract based on filing an I-485J, but it is something they do have to provide some data and information to the government so that the government is comfortable that the physician is working in the same or similar position as they agreed to. And the next, I just want to talk briefly about the green card. So this is a top benefit to IMG physicians. More than likely, they will bring this up. They may bring it up as part of the contract negotiations. They may use this as a way of screening which employers they want to go with, because 99% of the time they do want to have permanent status and eventually become citizens of the U.S. So they will sometimes ask for employer sponsorship. And what that employer sponsorship means, oftentimes ask for employer sponsorship, but what that employer sponsorship means is that the employer is agreeing to apply to the Department of Labor and go through what's called a labor certification process, where they have to prove that they are unable to locate or they have not been able to attract U.S. citizen or permanent resident physicians for the position offered. So it basically means that they haven't had a hard time finding physicians for their position, and as a result, the government should certify the position as a shortage position and qualify the physician as the person to take that position. So even if the doctor is already working, already been employed with the sponsoring employer, they still have to prove that there is a scarcity of U.S. citizens for the position that's being offered. So it is a very complicated process. We don't have time to go through it here today, but that is what most physicians, or that is a way that most physicians get their legal status, is through this labor certification process. So they are usually wanting employers to commit as early as possible to start that process so that they can get their permanent status as soon as possible. There are some other ways for physicians to apply on their own. So for example, one way is the national interest waiver, which is where they can sponsor themselves, but they have to commit to working in 5 years in an underserved area. That type of employment can be self-employed, but especially for J1 physicians, this might be an option for them. And so sometimes they might request a 5-year contract as opposed to a 3-year contract so that they can qualify for the national interest waiver. There are 2 other ways for a physician to qualify self-sponsored, but they are very, very difficult and requires them to show a lot of national recognition, not necessarily Nobel Prize, but they have to show that they're considered to be a top doctor in order to qualify for those types of self-sponsorship. So it's very rare that you're going to, the physicians are going to be able to do that, although it's very feasible. We work with physicians who do that all the time. It is feasible for some physicians, but most physicians will need either the labor certification or, if it's applicable, the physician national interest waiver. So we've gone through J1 physicians, H1B physicians, some of the other types of work authorizations that you might encounter. So if there are any questions, I would like to open it up for questions. I haven't seen any so far in the chat or the question pane, but if you have some specific questions that you have been on your mind because of current candidates or things like that, as long as you post them without identifying information, I'd be happy to answer those. So I'm going to give you a minute to enter any question that you might have for those of you on the call. Okay, I have one question. These regulations seem fairly static. Any recent changes I have made? Yeah, you're right. It has been pretty static. We haven't seen many changes. We've seen a lot of, proposed bills in Congress, because this typically has to go through Congress for there to be really any change. But none of them have really panned out. The change that I could say is probably here is, as you said, there's a new agency for the waivers. There might be some new agencies that are on the horizon that will start to offer waiver sponsorship as well. But as far as things like H1B, J1, what the requirements are, the green card process, there's very, very few changes in the basic structure of it. Sometimes there's changes that I haven't gotten into the weeds about, so that does happen. But really, there's really not any structural change to the system at this point. But I would keep on the lookout for any we keep on the lookout for any new bills that come out, and do recommend that if there are bills that are favorable to recruiting, physicians, foreign physicians, making it easier, definitely, I would suggest to help lobby for that as well. Call your congressional rep or senator to voice your support for those types of bills. There was a question that says, are there any new programs on the horizon, like the ARC? Yes, there are some. We've heard of. There's not there yet. I think this coming year we should see at least 1 or 2 new programs come up. They will probably be regional as well. There will be federal programs. The state programs are going to stay the same unless the federal government agrees to increase the 30 slots that are available to state programs. That could be something that happens. But the other programs that would come on the horizon typically will be federal programs. And they usually are regional and also have specific requirements. The only program that isn't regional would be the Department of Health and Human Services, but that's limited to primary care. Okay, those are great questions. So I don't see any other questions. I think I'm just checking. Yeah, I don't see other questions. So I just want to thank you all again for attending. This will be recorded, so if you will receive it if you'd like to share with any colleagues or even with candidates or whomever, or clients, please feel free to do so. If you have any specific questions or candidates that you want to screen a bit, then feel free to contact me at ann.badmus@badmuslaw.com. We also have a website, physicianimmigration.com, that is focused on physicians and medical professionals. So feel free to visit that website for any updates as well. If you have any positions that you want to be posted, we also post those on our website as well, for physicians who are looking, or we refer potential clients or clients to our website for that as well. So again, thank you so much for attending today, and have a great afternoon.